Marcus with the city.
Lori Carnahan, Human Resources.
Jill Jolliver, Douglas County Administrator's Office.
Tony Wheeler, City Attorney.
Doug Green, Fire Medical.
Sean Coffey, Division Chief, Interim Fire Chief with Fire Medical.
Jason Williams, Local 1596.
Aaron Payne, Local 1596.
Dean Garrison, Local 1596.
Seamus Alberton, Local 1596.
And I'm Casey Toomey from the city.
Audience.
Jack Nolan, Fire Medical, Local 1596.
Dylan Brown, Local 1596.
Dave Sherman, Fire Medical, Local 1596. Charlie Biggerstaff, Local 1596.
Nick Simon, 1596.
Steve Weaver, Fire Medical.
Jack Emerson, Local 1596.
Allison McCready, Douglas County Clerk's Office.
Welcome. Dean, you want to do the honors?
Yes, sir. So opening statement, the purpose of these meetings is to discuss issues concerning wages and/or fringe benefits and/or working conditions between the City of Lawrence and the elected representatives of the International Association of Firefighters, Local 1596. Pursuant to Resolution 6817, these discussions are to be open to the public unless it is mutually agreed to have them closed to the public. However, there will be no public comment during these discussions. Observers are expected to remain silent and are asked to silence their cell phones. Proper decorum for a business meeting shall be observed at all times. Anyone who disrupts the meeting will be asked to leave. Ground rules have been previously agreed to by both parties. The city manager and the president of the International Association of Firefighters, Local 1596, will co-chair the meetings. The city and the IAFF shall designate a backup co-chair for the meetings. These meetings will be recorded and posted to the city's website.
Thank you. Exchange of materials.
No, sir.
Lori, I think we handed out.
The language regarding use of family sick leave for qualifying agency leave and military caregiver leave. Want to go through that, Lori?
Sure. This was related to the parentheses in section 9.4.4 that we talked about last time that you had brought the DOL fact sheet 28M for. And near the end of the meeting, we had indicated that we would bring back actual language that could be incorporated into the MOU. And you'll see at the top there, the current language that's in the MOU with the parentheses in it. We propose the language below that be replace that section entirely. And it reads, section 9.4.4, family sick leave. Sick leave may be used annually for illness with the immediate family, which shall be defined as spouse, child, parent, sibling, grandparent, grandchild, corresponding in-law, domestic partner, or step relations, or any other relative residing in the same household. Family sick leave may also be used, subject to the limitations outlined below, and as described in Department of Labor Fact Sheet 28M, which is attached in the appendix of this agreement, as follows. Qualifying extingency leave for a qualifying extingency arising out of the foreign deployment of an employee's spouse, son, daughter, or parent, or who is a member of the armed forces. There's not an or in there. And military caregiver leave to care for the employee's spouse, son, daughter, parent, or next of kin, provided they are a covered service member with an injury or illness as defined in DOL fact sheet 28M. Member working I believe that's supposed to say 2912.
No, I think you're right, and it should say members.
Member working the 2912 schedule may utilize up to 144 hours annually. Members working the 2080 schedule may utilize up to 48 hours annually.
Questions?
No, sir. You think that reflects what we discussed?
It appears to reflect what we discussed, and we'll look at it closer.
All right.
And then I also had indicated that I would have some other data here today, and I do not have it ready. I'll have it
What was that
Wednesday.
information?
There was some stuff that had to do with when we talked about wellness last time, and I was going to bring a couple other things I had in my notes that our office is still working on putting together in a format that we can use.
Okay. For those that might be wondering about the definition of exigency, it's an urgent need or demand. And then they give as an example, women worked long hours when the exigencies of the family economy demanded it. Synonyms are need, demand, requirement, want.
Now does everybody understand exigency? Okay, you want to go through the format that we intend to follow today? Want to show the screen?
Sure. We have, and I placed, at the end of the meeting last time, we had decided the agenda starting today would be those things that were considered management rights by the city when we put forth the items we were interested in discussing. They are listed individually by number on the agenda. What we have to track this, and I emailed that out to all of this group last week, is a spreadsheet that takes the current MOU and divides it by each sentence and section all the way through the MOU as it currently exists. The IAFF proposed the proposals that you had given us on the week of the 20th of April 20th. I included pretty much verbatim out of your letter in the IAFF proposed column. The city proposed column, I included everything that the city proposed on the 29th of April, along with the updates that were presented at the May 8th meeting. So the city had some proposed language there. What's not in there is anything that's not yet proposed, like for instance this language. I did not include this language in the city proposed. However, I would include that today going forward as a formal city proposed language. And in the last column, I tried to archive where we were at based on our discussions of May 6th and 8th. And in as few words as possible, tried to outline where we were at with things. And probably a good example of that might be on page 19. We talked during the May 6th and the May 8th meeting a little bit about callback and overtime. And we left from what my notes had in it on section 8.7.1, we discussed it on May 6th, and we also, on May 8th, the city proposed some language which is included in the city proposed column. And I had a note from the end of the meeting that all of the items we had discussed thus far, the IAFF wanted to wait and TA until all items had been discussed. So I used that same language all the way through for where I felt like that was where we were at with some of those items. If you go to the next page on section 8.7.2, again, we discussed, that's the one on overtime. We discussed that on May 6th. But we had no conclusion. I felt like we left that meeting just outlining the thoughts, and there was no conclusion on that.
What section was that?
8.7.2,
Referring to?
overtime calculation.
Okay.
And so on and so forth through the MOU for the things that we had previously on the agenda. I think most everything on this document, Casey is at the keyboard now, and we can have Casey do that or rotate around if we want to. We can continue to use this as a working document, kind of a brief, not really a minutes of this meeting, but an outcome of each of the sections as we go through it. And if we TA things, we can mark that and we know that those are finished. Or we can know, I think one of them I marked that I had some data that I owed this group, and I marked in there that as well. And so the things we discussed today, I would imagine that we'll have a 5, 13, 19 in some sort of status.
Questions? Dean?
No, sir.
Anybody else?
I will send a new one of these out, or Casey or I will send a new one of these out after every meeting so that you always have the updated version, almost right after every meeting.
Okay, so with that, we'd like to begin the discussion about management rights. If you would, I'd go to the resolution, number 6817, which is a resolution setting forth the policy of the city of Lawrence, Kansas with regard to employee organizations and amending resolution 6690. And under section 5, which is the third page of the resolution, it begins to describe management rights. And it says, the following topics are considered management rights and are not subject to discussion. Then it goes on to say, management may, first one is direct the work of its employees, hire, promote, transfer, assign, and retain employees, reprimand, suspend, and/or discharge employees for proper cause, maintain the efficiency of governmental operations, relieve employees from duty for lack of funds or lack of work, determine the methods, means, materials, assignments, and personnel by which city operations are to be conducted, take any actions necessary to carry out the mission of the city, initiate, prepare, certify, and administer its budget, and exercise all powers and duties granted to the city by law. So that's the premise under which we start the discussion for management rights. According to the agenda, the first item for discussion is the preamble. And we have presented different language in the table, and I think Casey's bringing that up so that you can see the comparison. I think the big difference is the emphasis on the resolution, and it establishes the relationship between the city and the employee group, in this case represented by the IAFF. There was a section in here, Tony, that referred to employee too. Do you recall what section that was?
In the
recital, in the,
In the resolution? It talked about the individual employee.
yes, it's on page 1, it's in the recitals.
Okay, so the fourth recital indicates, this would be page 1 of the resolution. The governing body of the city of Lawrence, Kansas believes that the interests of both the city of Lawrence and its employees are best served by maintaining the two-party relationship of individual employee and employer. It then goes on to talk about how employees as a group can then organize. And so I think that's a significant piece of the resolution regarding the relationship between the employer-employee and then the establishment of the management rights. So we'll refer to that as we go through this. But in the preamble, the major emphasis that we're trying to point out is that this resolution really sets the stage and creates the authority for our relationship. And a couple things I want to mention to you. If you go to the second to last paragraph, it talks about modified interest-based bargaining process. But then it qualifies it by saying when appropriate to resolve conflicts and address concerns. And it says the process promotes a win-win model and builds a strong relationship between the parties. And we had this discussion, I think, on the very first day of having those discussions. I guess I would point out, as I did in that first meeting, there's all sorts of forms to negotiate under. And even this suggestion is only suggested, it's not required. The relationship and the process for negotiation is really what's defined in that resolution. The other thing that's mentioned in here that we don't continue to refer to is nothing in this agreement shall be interpreted to prohibit a city commissioner from attending a negotiation session. Certainly in the public sessions, we've had elected officials, both in the LPOA and the IAFF. I can't tell commissioners what to do, but the relationship with the city commission and the IAFF or any employee group is also defined in the resolution. So we go back to section 3, and in the resolution, it says an individual employee may exercise the right to speak or consult with members of the city commission on any subject without fear of reprisal. So I think again, that being the authorization means that you as an employee, and if you choose to be a group of employees, you can talk to the commission whenever you choose to. So we think that is the authoritative language that creates our relationship again, and that's what should be referred to, not necessarily this statement. Although nothing in the agreement prohibits a commissioner from attending a session, so we have changed that language, again, referring to the resolution. The next section on the agenda is successors.
Tom, I just got a quick question. You mentioned that these proposed changes are so that it's more in line with the resolution. Do you not feel that the current language says that this is entered in pursuant to 6817? That's the first line of the preamble that is currently in the MOU.
Yeah, I think it does, but I think some of the other sections take it beyond it.
Okay, which?
The ones I mentioned. I think they're additives.
Okay.
At best.
You also mentioned that you want
And
to.
they're not binding.
You also mentioned that the proposed language is an attempt to establish the relationship between the local and the city.
No, the resolution.
The resolution,
establishes.
okay.
Anything else?
Nope, I just wanted to point out that the very first sentence of our current language says
Right.
it's entered under 6817, and
Okay, the next section is successors. And I'm not really sure the history of this, but there is a significant emphasis on this memorandum shall be binding upon the parties and their successors, and no provisions, terms, or obligations herein contained shall be affected, modified, altered, or changed in any respect whatsoever by consolidation, merger, or annexation. Our language is a bit more general. It says the memorandum of understanding is the controlling document superseding all previous agreements and all existing unwritten practices between the city and the IAFF, and constitutes the entire memorandum between the parties pursuant to Article 4 and Article 6, entire memorandum of understanding. Was there an issue at some point in the relationship where there was a fear of consolidation?
There isn't a history of fear. but these things are put in place because we can't predict the future.
But the agreement controls regardless of those things happen. If something were to change in the term of the agreement, we'd have to come back and seek an amendment, which is bilateral. It seems like there was something that created that angst or concern that they would have put it in there that strongly. And maybe the history I'm thinking of is the history between the city and the county that created the fire med department to begin with, the combination of the two. But most of those provisions, at least as history's been recalled to me, seem to favor the employees in that relationship. Go ahead.
I'd also point out that if there was a consolidation with the city and the county, that would be a several-year process, I would think, and quite a bit of planning would go into it. And these agreements are generally short-term. So if that was on the horizon, I would think it could be addressed in negotiations.
What's the relationship, though? You know, I can understand why the union might have a concern if an agreement lapsed, and these agreements potentially can all lapse, I suppose, although the provisions are pretty tight in terms of timing to get them, negotiations resolved. Is that the concern, that it would lapse?
I don't think the concern is that it would lapse. I think the concern is to have something in here to cover any possible scenario.
Tom, when we were talking about earlier items, you talk about trying to build articles and sections in here that are for all situations. Specifically, you were speaking to financial situations. We should build a contract that can handle and forecast, right? I think that's the intent of this section we're discussing, is to, keep it watertight for all situations.
Except that by specificity, you're actually limiting it. If you read the language that I think we're suggesting, our language says all existing unwritten practices and everything else are embedded, all of those things have to be embedded in the agreement. And so the agreement essentially supersedes, even when, quite frankly, we have gone above and beyond our own resolution. I still need to come back to you and have that conversation with you. I can't just unilaterally remove something. So when we go through these management rights, I hope to be able to convince you that those are precluded by the resolution. But I just can't take those out. I mean, ultimately, if we go to impasse, ultimately, if we go to a decision by the city commission, they can make that decision, but I don't have the authority to make those decisions. I can point them out, and I'll point them out through the process, but ultimately, the commission makes that call if it's done against your will. The thing I don't understand is how the city modified their own resolution through the agreement. I mean, without modifying the resolution. The authorizing document and this contract are in conflict with each other. And I don't, somebody could say, well, management was asleep at the wheel, or somebody could say that the union used incredible finesse to get those things to change. But they are contrary to the resolution, and I think you'd have to acknowledge that when you see the two documents.
With respect, Tom, I think it's possible that these things you're referring to are in the document because other groups and other city commissioners had different perspectives on how a law is interpreted.
I'm not sure they consulted legal counsel. Anyway,
that's our proposed language on that particular issue. The next section is Article 4, Appendices and Amendments.
So we have talked about this before, but I think that what we wanted to inject in here is that we recognize, and we ended up doing this with the LPOA, that as soon as this agreement is written and as soon as every other agreement is written, interpretations start to occur where the specifics of a situation get applied to the language that we just approved. And sometimes in the case of like the LPOA, I think Casey, wasn't it an issue of overtime interpretation?
I think the one that comes to my mind was the effective date of the general wage adjustment.
Yes.
There was a disagreement between our payroll staff and the LPOA of what the language exactly meant in terms of that effective date.
Yeah. So instead of going back through a formal major amendment to the contract language, this section creates the ability for both parties to sit down and enter into letters of understanding so that we can get those things clarified. I think it's a less formal process, but at the end of the day, it documents the differences and how we resolve them. And then that gets attached to the agreement. And so that the next time the agreement comes up, you'll have all these letters of understanding attached, and we can formally modify the language of the contract to embed those letters of understanding into a formal amendment if that's required. And so it's a bilateral approach, but it isn't so overly formal that it slows down processes like, you know, when that check was supposed to be effective with that contract. And I would tell you, and you can talk to the LPOA representatives, there was no dispute on either side that it could be interpreted either way. And so the language wasn't crafted as well as it could have been. So the letter of understanding really facilitated, I think, a resolution that was more timely than it could have been through a formal amendment process. And it allows the city manager and the president to sit down and have those discussions and get those things resolved. And in the case of the LPOA, the full negotiating team sat down with our full team. So it isn't like two people are just sitting in a room resolving those things. It's, you know, everybody's perspective on the executive team of the LPOA, in your case, the IAFF, and the city management team sat down and got those things resolved, so.
Tom, where it says these discussions shall not be considered negotiations nor subject to impasse to the resolution, with this language, when at one point, if the issues can't be resolved, does that move into a formal amendment
Yeah,
process?
then you have to go to a formal amendment process to
Okay.
get something done. But, and let's be completely open, it's really how you describe de minimis or how you describe minor issues, right? Some of these will lead to contract language amendment, but sometimes it's like one or two employees that are affected that you didn't consider in the process. We try to build this language with a uniform understanding of how it applies to everybody. But not everybody has the same circumstances. So you get into those arguments and those decisions where somebody has a really odd circumstance that was not considered. And so it doesn't necessarily, you know, result in a major pay adjustment across the entire operation. It's really those situations where you have interpretations where a smaller number of employees are impacted in a way that wasn't expected or either side thinks is fair, okay, to do that. And if you read the letters of understanding between us and the LPOA that's resulted from this procedure, you'll see that it works out pretty well. In fact, I think we agreed, you know, in favor of the employees in all cases in those.
I believe so.
Anyway, it's trying to remove, you know, quite frankly, when we say it isn't subject, Seamus, when you think about the process for an amendment, it's probably no different than the process for the formal ratification of the entire agreement to begin with. So, from our standpoint, we'd like to cut through some of that stuff and get it resolved. And that's what this process is intent and is designed to do. So that's the major section change there. So the next section is it Article 6?
I think we're at 5.
All right, Article 5, okay, representation. This section refers, and I think probably one of the more important things to the IAFF is this removes the exclusive designation of you being the representative. And not that I expected you would know this, but exclusive arrangements with contracts are very unusual in the city section, in city government. And for example, Tony, the cable agreement, cable television, that isn't exclusive.
Correct.
And by that it means that while we had an arrangement with, it's now Midco, when we originally entered into that negotiation with the cable company, it wasn't exclusive, and it continues not to be exclusive. In other words, if somebody were to come in and match that proposal on those terms, we'd have an obligation to consider that and enter into that arrangement. I don't think the IAFF has anything to worry about, but the resolution says that we can't enter into an exclusive arrangement. If you read the, I think it's, yeah, it's the third, what do you refer to the whereases as?
Recital.
Recital. It says, whereas the governing body of the city of Lawrence, Kansas does not intend to formally recognize any employee union, group, or organization as the exclusive bargaining agent of its members. This is what I meant when I said that at times the agreement was drafted in such a way that defies the resolution. And I don't think the agreement, quite frankly, is, well, it's not consistent with the resolution, and I think that makes it questionable as to what, by what authority the two parties actually entered into that understanding. But I would tell you, I don't think, from my perspective, the IAFF has anything to worry about in terms of another bargaining group coming in and challenging the IAFF. But I point that out because I would guess that your international might have an issue with that or a concern with that, but I don't think you need to as a local personally.
Tom, would it be fair to, I mean, I guess it is fair to say that the city's main issue with current language is just the words sole and exclusive bargaining agent?
Yeah.
So, and this isn't don't consider this a proposal, but if those words were just removed, wouldn't that accomplish what the city's trying to accomplish with this long added language? You guys have respectfully have totally rewritten it instead of just removing the words that you have issues with.
I think we could have that discussion.
Okay.
I'm just reading it through again, Seamus.
But yeah, and I'm just trying to clarify, you know.
Yeah, that's, I think that's the major change in that particular section, as I recall. Laura, do you have any other? I mean, it further identifies management rights, but those are already embedded in the resolution, so reciting the resolution probably resolves it.
I would want to read it real closely one more time,
But we can have that discussion. All right. Next section is Article 6. I think.
yeah.
That's what we have.
Or was it all of Article 5? All
It was-
except 525?
Yeah, it was actually most of Article 5, so we talked about 5.1 just now. And we were interested in talking about 5.2, which is 5.2.1.
Oh, yeah, I think
Mostly
we
an
do
hours
have,
proposal.
I think we do have to talk about that.
Yeah,
We've actually reduced the number of hours, but there's an offset to what you see in terms of the number of hours. So the number of hours currently in the arrangement is that the union has up to 144 hours to conduct union business on city time. And we're proposing 72. However, if you go down to 5.2.3, negotiations are currently held on your personal time, right?
Yes, sir.
Yeah, and so what we're suggesting is, with the chief's permission, he could grant that, or she could grant that permission to be on your work time. And I understand that's discretionary, but that has to be discretionary from my standpoint as a management right in terms of assigning work. However, I think it would certainly make scheduling of these a lot simpler from the standpoint that your members who aren't all on the same shift, they could be coming over on their time, and those that are on shift could come over as well. I think the other thing, quite frankly, is as long as if we were gonna have public sessions, we could probably meet at one of the stations too for these discussions, as long as we could film it and things like that, so.
These are all things that we've done in the past. We've done negotiations on duty, we've done them at fire stations and things like that. The intent, this year, we just suggested to do it on our off-duty days, being conscious of the overtime budget and staffing needs, but that's never been a requirement to do it off-duty.
Yeah, I believe the current
then the
language
hours
in
are-
the MOU already allows this.
But didn't it count towards union time then? The way the document reads, it would count towards union time. Maybe they didn't do it, but the document says that time would have counted towards your union time.
Okay.
We're just trying to help you out.
Oh,
I appreciate you
I'm not
pointing
saying
that out.
that, I'm
Thanks.
just letting you know. Help me out.
So you think it's better for you to keep the number of hours set the way they are?
Well, right now, we're listening to the city's perspective on this proposal.
Okay.
So we'll be able to discuss it later.
Okay. And then under 5.2 is the next one 3? Yes. Basically, this proposal goes from the union or the IAFF notifying the city to securing permission from the fire chief. It seems to me that the chief still needs to direct the work. 5.2.4, we think that's already addressed in 5.2.1. In terms of the number of hours, and is not necessarily to repeat it. And so maybe we need to have further discussions about that after you've had a chance to look it over. What's the next one? 5.6?
5.2. Yeah, 5.2.5, we agree that the current language is good.
Yeah, there's no change. 5.2.6 regards dues, and we've added language that says the authorization, these are dues checkoff, and we've added language that says the authorization form will clearly state that IAF participation is voluntary, and it'll be signed and dated by the employee. 5.3, this is regarding a provision for dues checkoff, which we propose to eliminate dues checkoff. We're trying to get out of as much dues checkoff to begin with in terms of the payroll, trying to make those arrangements.
5.3.
Why is that, Tom?
The administrative responsibility and cost for doing that. The PAC is really not from our standpoint, isn't who we recognize. That PAC is a separate entity to you, right? To the IAFF. We don't have a relationship to the PAC. It's exclusive to you and to the IAFF, right? It's not a part of this negotiation. We have, for whatever reason, acceded to doing dues checkoff, but that's not who we negotiate with. Is it the same board as your board? Or is it
No,
a different
sir.
executive board? It's a different group?
Yes, sir.
And-
It has a chair and a treasurer.
Yeah.
Okay.
We
Quick
think
question.
that, we think that there's some precedential impact as well as to other organizations demanding that we provide that checkoff.
Mhm.
And honestly, we've had that conversation internally regarding, social services and other groups asking for some form of dues checkoff. Because of the nature of a PAC, this has a political overtone to it, and on a precedent-setting basis, that's not something we wish to get into. I think from a legal standpoint, we have concerns that others may demand that sort of thing from us that heretofore haven't, but could going forward, so we have concerns about providing that service.
May we back up to the previous article, 5.2.6, section 5.2.6,
Sure.
and just review what this really means on an annual basis?
5.2.6,
Yes,
we're
sir.
at.
So one right before.
The voluntary.
Yes,
and-
sir, so
and
we
the sign.
understand emphasizing that membership is voluntary, but wouldn't this change to where to renew each year, that those dues change annually, it's up to the member to complete a form rather than the treasurer to complete the form on their behalf.
I think it would require the IAFF to distribute a new form and have its members sign off on it annually to turn it in, instead of a summary document.
Okay, so we're hearing stuff like, pretty much probably, I think, do we know for sure that this is going to result in each member having to complete paperwork, or will the treasurer be able to represent them?
Oh, no, I think each person would need to complete it,
Okay.
or at least sign it
Mhm.
and date it.
It says, Dean, the authorization form will clearly state that IAF participation is voluntary. It will be signed and dated by the employee
Mhm.
who wishes to use the payroll deduction system. Is that consistent with other deducts?
For most things, we require that for our flex spending each year. We don't require it for health insurance changes, or health insurance if there's no changes. United Way and health clubs, you have to sign up for every year. So some of the things that we do that are not, internal benefit programs, those have a 1-year time span, and then employees re-sign up for those. Yes.
The deduction will continue each pay period at the same amount until the employee submits another signed authorization form. So when I read that, I read it to mean that it wouldn't be annual. You
Yeah,
would,
it's only
do the
when,
form
probably when
once,
the rate changes.
and then if you needed to change it, it would require another form.
So is it fair to say that the city's priority is to emphasize that dues checkoffs to the IFF should be voluntary, and that employees are aware of that?
Well, it's not only voluntary, but that the employee is signing off on it.
Okay, so wouldn't it be more prudent just to add that to current MOU language instead of proposing an entire rewritten? Because that's currently how we operate, and if you want us to put something in, it is voluntary.
And the form says it is?
Yes.
Okay. So you can counter that then?
We'll have to look at this further, but I don't understand why the city would like to propose completely new language instead of just adding the, ensuring that there's a form that says the word's voluntary or can cancel at any time or something like that.
I think our effort is to make it clearer. I think we did incorporate some of the existing language from the agreement as well. I think we're trying to develop some consistency with these dues deductions across all groups, so there may be some internal equity arguments associated with that too. All right, next is, are we at 6 now?
We finished with 5.3.
5.3 was the,
Yeah, that was the PAC.
Okay, I
Cover.
wasn't sure if we were finished with that discussion.
and then 5.5 had a little bit in it as well.
Yeah, this is one where I don't think the city has much knowledge about how this works at all. And this is referred to as, currently it's referred to as union coverage, and under section 5.5, the change, we've said IAF coverage. And Our language says the city retains the discretion to approve IAF coverage in accordance with the department's standard operating procedures. And note, the city would like to have discussion about IAF payments. So as I understand it, I think the Fair Labor Standards Act refers to some provisions that a fire union, maybe other types of unions, can actually pay employees on these shift trade ideas or circumstances. Is that the case?
Yes, sir. We want to know here, though, many of these proposals are loose and really requesting discussion. We're requesting a discussion here. Is there an actual proposal? This is an issue that we've dealt with internally and feel like has been resolved. We can entertain a discussion, but that may be separate from contract negotiations.
Well, we think it's part and parcel of contract negotiation.
Okay.
Here's the issue. Somebody else is paying city employees to perform work. Do we have any liability for those situations as to IRS or state of Kansas deductions? Who's handling that? Is the union deducting money to make tax payments on that? Is that subject to tax? I mean, if it's payment for work being undertaken, it seems to me that there's income tax implications that have to be made.
Okay.
Under the law, is the employee responsible for that? Are we not, I mean, they're in our employment, but somebody else is paying them. It seems exceptionally awkward to me, as to who's responsible, because in all other cases that I'm aware of, even outside work, a lot of those payments come back through the city to make sure that deductions are made and that shows up, for all sorts of reasons. Final average compensation for pensions and all sorts of things. So it seems a bit odd that that circumstance exists. On the other hand, the FLSA apparently says that that's acknowledged and they recognize that that occurs. But are we clear that we have no responsibility for those payments, for that monitoring of the IRS or the state of Kansas income taxes, all of that? That's the question.
So we understand how this language is confusing, and then internally we have jargon, so to speak, terminology like union trade versus regular trade, but it's all trade. It's all just a trade. It follows the guidelines of a trade, follows department policy, and we say union trades as a way of building membership morale. You're doing things that's related to the local, but it's just a trade, and we're very specific to let every member know that it follows our trade policies as set by the department.
It follows the trade policy set by the department. What does that mean, Dean?
So we have a policy where if you trade time with another member, then the payback, so to speak, is between you and that member. And the department isn't responsible for it. So you owe them time. So if I work 24 hours for you, you owe me 24 hours. And that's between us. We complete a trade form. Our immediate supervisor approves it. The ops chief then approves it. And it's then added to the calendar.
So at the end of the year, is it a complete wash?
It's between those two members.
But, Dean, if somebody's netting more money in terms of income, isn't that subject to income tax? And who's responsible for that?
So it doesn't change the payroll. Payroll just
Well,
remains the same.
I get that,
Mhm.
but it may change what somebody earns at the end of the year to be different than what our payroll shows. Isn't that the
The
case?
city wouldn't pay a person that's working the trade.
But somebody's paying them, and they're on our time. That's the point.
Okay.
And then who's covering that income tax?
Mhm.
Is the union?
So we have an obligation to the IRS. We submit our taxes every year that reflect all business we do.
As the business entity, but
Mhm.
not as the entity that is arranging these trades between people.
Okay.
And if there's a net differential there, isn't that subject to income tax?
Okay. Well, sir, the trades are a wash, in regards to payroll for either organization, so we can,
So we could come up with some language that removes any liability from the city for those situations.
we could entertain some language and review that.
You'd indemnify us.
Well, okay.
That's why we wanted the conversation, because
Okay.
we don't really know how this works
Mhm.
and what our liability is or is not.
Okay.
I think
I mean,
We want to
it-
be
it-
clear about that.
it would be the same as any other trade.
Yeah, I mean, on a regular, just a trade, let's forget about the union aspect. If me and Dean agree to a trade, I work 24 for him, he works 24 for me. And when I'm working 24 for him, I am not being paid by the city for that. It's no different. It becomes a wash. Are you suggesting that you wouldn't be liable for me when I'm working a trade as far as?
It's not the work part of it, it's the income part of it that I'm concerned about, and whether we're gonna end up with some sort of income tax obligation.
Okay.
Or process concern.
No. I realize the language says that we have the ability to pay members, so if there was a motion driven to do that, we're currently protected by contract to do that. But,
I wanna make sure the city's protected.
okay.
That's
That's
my
fair.
concern. I don't intend to change the trade process.
Mhm.
I think that's built into FLSA. I just wanna make sure that we don't have any obligations in terms of tax issues.
Okay.
And maybe by talking to your international or other bargaining units that have dealt with that, there's some easy resolution to that.
That's it for Article 5.
Okay, the next provision is Article 6, entire memorandum of understanding. And what this really tries to get at, from our standpoint, to cut through it, is an understanding that the memorandum of understanding supersedes everything in terms of what is identified for pay, benefits, and working conditions for the members of the IAF local. The concern, I think, is that neither party is prohibited from bringing anything up during the negotiations to discuss. But when those discussions are all done and they're refined to writing, that's the end of it. Past practices that nobody thought of or concerned themselves with could be addressed through the memos of understanding, letters of understanding, or by formal amendment. But thinking that we can just have a past practice and say, well, that's how this has always worked, and there's some language to the contrary to that, to me, that takes a bilateral approach to resolution. It's not just unilateral interpretations.
Did you want to add anything to that?
I don't believe so. This is something,
All right.
I think.
You can interrupt with
Okay.
questions anytime you choose during this, so if you
I-
want to,
I do think the first sentence was of interest as well, that it's superseding everything existing,
right, that's the
previous agreements.
previous practices and so forth. Okay. So the first thing that we did with Article 7 is we don't have rules and regulations, we have policies and procedures, so there's a minor title change issue there. We also think this is a management right from the standpoint that the chief can implement rules, and consistent with the management rights language in the resolution, the bar there is pretty high. We're not even supposed to discuss those, but I would say to you that my expectation of any department head is that when rules change, that they have an obligation to sit down and discuss those policies and procedures, rather, before they do that. I think that's just a normal good practice, unless it's some unforeseen emergency that comes about. And then I think it would be obvious what the logic is for that, but
Do you think the current MOU language ensures that happens?
well, again, I would say, Seamus, that as, you know, the management of the department, meaning the chief and the captains and the chiefs, they ultimately have the responsibility for the management of the department. And like I said before, in most cases, those individuals are gonna be people that came up through the ranks that all of you represent. So they're gonna have those kinds of understandings. Can you get a personality that maybe is not the most popular? Yeah, you can. That happens. And I don't know how you necessarily avoid that in the process. But I do contend that to be a good management employee, you do have to understand the needs and the desires of the people that are working for you in terms of the leadership capacity that you have with those employees. I'm not sure that you ensconce it in writing, that it changes anything in terms of what the discretion of a manager is to begin with. But I would.
So you're saying the current MOU language doesn't change the chief's ability to change SOPs, have the discretion to change SOPs? It just ensures that the conversation happens?
I would say that I think that just by merely putting that language in there, in fact, I think the language still comes back down to the existing language still comes back down to it's still the chief's call in all of these things.
So you agree the chief still has the decision to make those calls?
I think the chief always has that discretion. And quite frankly, to put a lot of words in there that suggests otherwise, I don't think gets you anything.
Tom, this also outlines if there is a disagreement with the IAFF on the regulation, it addresses that grievance procedure that we
Yeah.
have concerns with.
And we've had this discussion about the grievance procedure before. You have in the, exclusive to the fire agreement, you have what I refer to as kind of the class action ability to challenge a rule or regulation.
which is different than the employee handbook grievance procedure. The resolution comes from the city commission. The city commission is the ones that had the authority and continue to have the authority to allow for these negotiations. The language in the IAFF agreement provides for basically a third party to come in here through arbitration. They call it mediation, but the settlement or the decision is binding, which makes it more akin to binding arbitration than to mediation. Mediation is typically voluntary, like it is in the other parts of our agreement, or in the resolution as we move through negotiations. And in that case, it goes to the city commission, and the commission ultimately decides what the agreement's going to look like. In the grievance procedure of the city, when you have an aggrieved employee, we have to send a copy of the management decision onto the city commission. And the city commission can then look at the policy and actually alter the policy retroactively, presumably in the favor of the employees. I think that's the more appropriate way of doing things.
So
They retain that authority, and somehow we have managed to give that authority to a third-party arbitrator / mediator.
So, Tom, you're talking about the grievance process. Do you feel having this language where it ensures the fact that these conversations are happening with employees, that it could, keep some of those grievances from happening? Before it ever gets to the level where the union or even an employee would have to grieve a policy, these discussions are happening in a non-contentious format.
I'm willing to discuss that in terms of how that language might read, so that we do, we have some statement, certainly of philosophy there. But you agree, it's ultimately the chief's decision, right?
I believe our current language already allows the chief to make decisions, yes?
The agreement doesn't allow the chief to make the decisions, the resolution does. That's where the management rights are stipulated. And anything that this agreement does to alter that, I think is incorrect. Yeah.
And I'd also point out that our employee handbook has very good language about how the city likes to deal directly with its employees, and it encourages employees to bring matters up with their supervisors. So it could be argued that this language isn't even necessary because that type of discussion is already provided for in our handbook.
Any other comments?
No, sir.
Where are we at?
We're on Article 8, compensation. For the most part, that's not under the management rights, but there was 2 sections that we wanted to point out in this discussion, even if it's pending until a more
Can
compensation-related
you
discussion.
point those out?
Sure. That would be 8.2.3, which reads, if the city institutes a greater general wage adjustment to any city employee, employee group, or bargaining unit during the term of this memorandum, such general wage adjustment shall also be instituted for employees covered by this agreement. We wanted to point out that we felt like it was covered, that it fit this category, but might be a good discussion item for compensation, but we will propose that it be removed at that time.
Yeah, that's the same discussion regarding favored nations. I'm not an advocate for favored nations. My expectation is that you negotiate what you believe is in your particular best interest. the other bargaining unit and the other employees, as you've pointed out, have not kept pace in terms of market competitiveness with the IAF or with the LPOA, from what I can tell. And so if we were to do a general wage adjustment to bring them up to where they're supposed to be, which it is my intention to do that, I don't necessarily think that that should just accrue to the IAFF after they've had the ability to negotiate what their wages would be in terms of market comparisons and anything else that they chose to bring to the table regarding that. And the other thing I would say in terms of favored nations is, if you're gonna want favored nations, that's a two-way street. Things go up, things go down. Why would I only agree to things going up? Why wouldn't I agree to things going down? I have to come back here and negotiate longevity with the IAFF. I didn't take that out of the agreement because you've got that secured by the agreement. I have to negotiate that. And while I'm sure there's pressure on both of us to do that, it still is a matter that has to be negotiated with the IAFF before it can be done. So if it were favored nations, my view is that that would apply. And so that would have already been impacted on you if it were a favored nations provision. So I'm not an advocate for favored nations. You have an unlimited ability to negotiate for what you think is appropriate for what your membership needs. And, you know, it's subject then to getting it done.
And then the other section under Article 8, compensation, that we wanted to point out at this point in time is the 8.6.1, which lists the number of acting officers that'll be appointed at any given time.
Right.
We feel like that is a management right to set staffing levels, and while and we also feel like acting officer is, the rate of pay for that is covered under a different section in the compensation section, that 8.6.1 could be eliminated.
Right.
And again, that could be a greater discussion at the time of compensation.
Next is Article 9.
Sir, real quick, before we move to Article 9, we're requesting a 15-minute caucus.
Sure. is cold, isn't it?
The HVAC.
Go until 10:30 today, right?
Yes, sir.
That was our understanding, yeah.
And I've got to be at another appointment shortly thereafter. I'm not gonna be here Friday. That's our next session. I have a funeral out of state that I have to be at. So our team will still be here. Lori will serve as the chair for the management side, so.
Yeah, I think
Yeah, we have one.
Wednesday?
Yes.
Yeah, I'll be here for that. But there's one Friday too, right?
And I
I
have,
believe so. I think we're Monday, Wednesday, Friday this week.
yeah, and I also have a note that Aaron, you're not,
Probably not.
probably not here Friday.
Okay.
Okay, which day?
Right.
So, coming out of caucus, did you want to say anything, or we can just keep going?
Keep going.
Okay. All right, next article is Article 9, the first section regarding general benefit provisions. This is again a favored nations provision. I think from our standpoint, everything should be embedded in the agreement. Again, it kind of cuts both ways, and in the case of the LPOA, they wanted to have the provisions that were current. And so I think if you look at the LPOA agreement, those provisions where we make reference to the employee handbook say the handbook is dated, so that if there were a unilateral change to a benefit, or even a negotiated benefit change, that wouldn't apply to them. I think their presumption was there was greater downside risk than there was upside risk. And so that's why we ended up with the way that is worded. You know, you may feel differently about those arrangements, but our view is that this agreement constitutes the relationship that we have. And in your case, I propose that we take any references to the employee handbook and embed them in an appendix, which would be directly attached to the IAFF agreement. 9.2, annual hours worked. Again, we reference the resolution which states that the determination of methods, means, materials, assignments, and personnel is the responsibility of management, so it's a chief decision in that regard.
Tom, as far as work hours, do you think, excuse me, let me back up. Are you citing methods, means, materials, or assignments? Which one of those languages would you say hours falls under?
Oh, I think methods and means, and assignments and personnel are all applicable.
Okay.
Materials not necessarily, but. Next is vacation, and, well, we didn't have that one, did we?
No, I think we skipped to 9.8.4
8.4.
for this topic.
All right.
I'm sorry, Lori, where are we?
8.4, 9.84.
9.84.
And that was,
That's holidays.
yeah, and this was, again, the same statement. Any other holidays recognized by the city and received by another city employee shall also be granted to the
Yeah, so
union
this is a
members.
favored nations provision. Again, the same argument applies there. And then 9.13 is the next section. had previously discussed this on May sixth, but we didn't reach a conclusion. And this is about reduction in personnel. And we refer this to the employee handbook, right?
Correct.
Language there.
What is the employee handbook language say?
The employee handbook language.
Yeah, why don't you pull it up and read it?
Casey, I may need to have you pull it up. I may need to have you pull it up on the employee handbook.
Okay.
On the electronic copy.
Lori, I think
Do you have the
Dean
section?
found it here.
What section is it?
It's under separations of employment,
Yes,
reduction in force.
yes.
Right.
And it's very brief, but I would need to have it up quoted.
What section
Um,
number is that?
Section 7.
7, yes, ma'am. Letter F.
Casey pulling it up.
I think so. I put the handbook as one of the sections in that flash drive. Go back one more. Section 7, separations of employment. This is the handbook language. The city has the authority to terminate any employee because of lack of funds or curtailment of work after giving notice of at least 90 days to the employee.
So what specific language does the city have issues with in the current MOU language?
We believe that this is something that the management has the right to determine this.
Which, I guess I'm not trying to be trouble. I really am just trying to understand. What, under management rights, what specific language is violating the management right to make the decision to separate employees?
This dictates the procedure that
So-
would be used.
So it doesn't dictate the right to make the decision?
No, I think it adds a lot more procedure than is necessary.
It adds procedure, but doesn't change the ability for the chief to make that decision?
It dictates how the chief would determine the layoffs.
Okay.
And that's his discretion, her discretion. Nine point 14.
And again, we discussed this with the employee handbook section, and
Yes.
we propose that it matches that language, and it actually already does. There's no change to content, just location.
We're saying that's the same.
Yes.
And then 9.15, 9.17 goes through the grievance procedure. We want to go to the employee handbook provisions on that. I think I've explained that on more than one occasion. No. Under 9.18, minimum staffing, again, we argue that's a management right, and that determination is under the exclusive purview of the chief.
What are we at? I'm sorry, what's the?
9.18.
9.8, 9.18.
This is a section that the IAFF has a proposal. Do you wanna?
Yeah, what did the, and the IAFF wants to put a provision in that we comply with NFPA 1710. Any idea how many departments around the country follow NFPA 1710?
Oh, when we come, when our agenda has our proposals listed, we'll come with some information like that.
Okay, next is 9.21, station maintenance. Again, we think that's the exclusive purview of the chief and the management staff at the fire department. Likewise with 21, 22, and 22.1. And 24 is going to department policy.
And the IAFF made a proposal here as well.
I presume they're gonna present that when they go through theirs. Next is section on health and safety. I think the only significant change is that the IAF shall recommend 6 members to the team. The chief shall approve all team members. Section 10.1, pardon?
Just appointment of team members.
Pardon?
On the appointment of team members for the health and safety, I think we currently have 12 members, is that correct? If that's still the same, we would still have the 12, 6 appointed by the chief, and then the 6 would be recommended by the local? Or are we just doing just 6 recommended by the local? 12.
Section 10.14. Is that it?
Yeah, same thing.
Yeah, same thing.
10.1.4, is that where you're at?
Yeah, all recommendations shall be directed to the chief with copies provided to the IAF president.
How do you feel this language is different than the current language? I guess I'm asking, how are you proposing the change?
So
the
that there isn't
spirit of
any
it?
misunderstanding that the chief and the union president have approval authority on these.
Does it,
I think it.
does it say
it's a
somewhere in
slight
our
di-
contract
I-
that the
I think it's a
president
slight
has?
distinction that it makes sure that that's the case. So,
Same with 10.2.
10.2.2. Again, this is a reference to the city employee handbook.
This particular section talks about assigning team members by the chief.
And the chief's authority to assign the team members.
We had,
And then we go to section 10.2.3.2 and 3.1 and 3.2. And you'll notice a question mark there. We're really, I need kind of the IAF's perspective on how this came about and how this works, if somebody can explain that.
What's specific to what?
Well, that, it says through the 82nd calendar day is not able to work 28, and the employee shall not be required to use leave unless the employee is on light duty. The significance of the 82nd calendar day.
Was a time frame developed by the city and the IAFF decades ago in the 1970s.
Oh. Is that kind of a standard procedure in that?
So we consulted the
business?
labor lawyer, and we're informed that it is, that both the public and private sector, it's not uncommon to have a 90-day window. Ours happens to be 82.
Yeah, that's why I asked.
And
how
issues
you
of
got to-
work comp.
Yeah.
Could you explain the 90-day window a little bit?
It's exactly like this, except instead of 82, it's 90.
That benefits are paid 100%.
Yes, ma'am.
In both public and private sector?
That's what we were advised.
So during that period of time, we make up the difference between workers' comp benefits and full pay. That's what these sections do, right?
Yes, sir.
Do we do that with all employees?
No.
How does it work with other employees?
The LPOA does have a provision that's somewhat similar to this. And Casey, if you want to speak to this closer, let me know. It's similar, but it has a different day number. It has 60 rather than 82. But for anyone outside of the LPOA and the IAFF, there is no city subsidy outside the state provisions for workers' comp. Lost work time benefits that's what it's called, lost work time benefits. And those start on the 8th day of lost work time at a percentage of your pay as dictated by the statute. And then beginning on the 21st day, if you're off longer than 21 days, it'll go back and pay the first 7 days. And again, it's a percentage of your total wages. Employees who would like to maintain a full paycheck during that period of time can take the difference between their regular pay and the state mandated work comp, lost work time benefit calculation. They can use benefit time, sick leave, or if they don't have sick leave, they can use other benefit time procedures, like vacation or something like that. So there's no 100% pay provision outside of the IAFF 82 days and the LPOA 60 days.
What I would mention, I think you talked about 21 days, 40 days, and then I think it's 7. That equals a 28 days period. And the 82 calendar days is equivalent to 28 working days for us. I think, for my best looking back, I think that's how they came up with that number. I don't
Okay.
know for sure, but I think
That's how the 82
the
was
82
calculated.
is actually 28 working days.
So, but the theory of workers' comp isn't subject to income tax, right?
Correct. Correct.
So you're getting paid net and not being subjected to income taxes. Is that at the state level too?
I believe that's correct. I'll have to confirm.
All right. And so in the case of this provision, the workers' comp policy pays the workers' comp rate, and the city makes up out of the general fund the differential between the worker comp payment and not with no regard to income tax.
How do we pay the income taxes on these 82 days? I would need to check on that.
Yeah, I'll have to check.
Does it
on
run
that,
through
too.
payroll or does it run through the work comp calculations the first 82 days? We would need to check.
Yeah, I don't wanna speak to it without double checking because the terms are different for each group. So I'll wanna go and look at a specific example of an IAFF covered person.
But this isn't like a supplemental workers' comp payment, this is just a payment under the guise of making
Right,
it
but
whole.
now that we have Thomas McGee on board, they handle a portion of it and we handle a portion of it, and I just wanna make sure that I'm reporting back to the group accurately how it's all handled.
But can somebody verify that workers' comp, you don't pay income taxes?
Yeah, I'll verify that too.
All right. Okay. Anything else on that?
We had just a
So,
question about
to-
the whole thing on whether it was a management right or an internal equity discussion. We weren't quite sure.
Yeah. I don't know that we're gonna come up with a proposal on that. That's why we put question marks. We just
Okay.
wanna understand how it works.
Mm-hmm.
And it could be, I suppose, an issue more of internal equity, how we treat everybody else, and how we would propose to treat everybody else to get closer to internal equity, so.
Tom, can I ask a clarification question?
Sure.
So, the 21 plus 7 is 28, and then it's 80, we think 82 calendar days is what's required to get through 28 work shifts, was that what I heard?
I think that's what Aaron was saying, yeah.
Okay, sorry, I can't see who's talking.
Did you have a comment?
No.
Okay, 10.3, 10.31 is referred to as modified duty assignment. Did we change the title? It used to be called light duty assignment. Is that how it's referred to?
Yeah, modified duty.
Okay. And is that one of your policies, or is that,
It's a program we have within the department for somebody's injured on duty.
and so this
Allow for
particular,
modified duty.
this particular policy is already embedded?
Yes, we've been using it.
Tom, we really, in this section, the language change in it has a lot to do with the requirement versus the chief's ability.
Discretion.
Yes, to choose if there is restricted duty available.
So tell me now, Chief, how do you determine a modified duty assignment? I mean, do you have to make something up?
Well, if it's modified, what we look at is typically if it's on duty, it's work related, we try to find a modified duty assignment form. They'll come in and do various projects for us that we can find. Sometimes it's a little bit of work to find a project for them. Last one we actually had him working up front, part-time as a receptionist, answering phone calls. But they also go around, deliver materials, involved in some of our programs and so forth.
Is it at your discretion?
On on-duty injuries, it is, but we've always treated it as we've tried to provide them that ability for them to work.
You always treated it, what?
As a work-related, we tried to find a duty time for them, if it's work-related.
It isn't just make work? Or is it in some cases?
Well, sometimes it is. There's loose ends. It also becomes a managerial part of it because if there's not an identified project that we have to assign somebody to, then you're kind of having somebody manage those people to find work for them to be able to keep busy. But if it's on duty related, we try to make sure we
But
have
it's
that
clearly
time for 'em.
it's your authority and discretion to assign.
Yes,
The tradition has been to find something for
yes,
them to do.
if it's work related.
I think to be accurate, though, this section clearly makes the distinction that it is the chief's discretion and authority to make those assignments. And quite frankly, could determine that there wasn't a project to do. Have you ever done that?
Not that I'm aware of. For somebody that was injured, or for work-related injury, I'm not aware of one in my time. Where,
Excuse me, Lori, is it still the city's philosophy that it's better for the organization to have people work because it gets them back to work quicker, as we were talking in a meeting a few months ago?
I think all of our departments attempt to find modified duty for people on work-related injuries. It's not always possible, but it's highly encouraged. We also ask other departments not to make up work. It has to be something that needs to be done.
Is this a good stopping point? It's almost 10:30.
Yeah, it probably is, Dean. Go through the completion of this list.
How much other items do we have?
We made a pretty good dent. We'll probably get through at least outlining them as we have been today. And I think we should decide after we get through outlining these, whether we go back and discuss for agreement, or if we move, what we move to next.
Well, Lori, we'd like to hear all the proposals in full before trying to reach any agreements. And we're also still curious, how many total proposals are there?
I think all the proposals are listed in this as they were on the 29th when we handed them out.
I realize they're listed in here, but some have question marks, some say wish
Okay.
to discuss, and so are we treating those as proposals?
I think a proposal might come from them, but it was dependent on the discussion. And
Okay.
that's why they had a question mark there.
Okay.
As we get through those, some won't have a proposal associated with them.
Okay.
So when we finish the management rights discussion, is there a category you would like to discuss next that we can prepare the list for? Or just all remaining things in the document?
I think we should just take on all the remaining items and we can describe whether they're internal equity or market. I think probably makes sense to hold all of the compensation issues to the end, because most of the compensation issues, most of what the IAF proposed were compensation type issues, I think, anyway, so that way we probably have a much more engaged conversation. You all right with that?
Yes, sir.
Is that right?
Right.
And our next meeting is Wednesday at 9:30 in this location, Wednesday, May 15th.
Missed one on our agenda when we were listing the management rights, 10.5.4, I think it was. So we didn't,
10.5.4.
Do we miss hitting that today?
well, we haven't gotten to it yet,
Oh.
but it was just, we missed it listing it here and we didn't wanna catch anybody off guard.
What's the
because
topic?
We didn't list it. I hadn't looked that up, I just wrote down the section.
Oh, here.
Fit for duty, annual physical.
Okay, so I'll add that to the agenda embedded in what's already here, and then we'll list the rest of them below that as new business. Does that sound good? I'll send out a new agenda and this updated document as well.